Hi friends, welcome to my channel. Today I am going to talk about limitation of liability clause. Before I start, I would like to request you to subscribe to my channel if you have not, so that you can get regular updates on my upcoming videos. Limitation of liability is much debated and much argued clause in any contract. A limitation of liability clause is a clause in the agreement that specifies the damages that one party will be responsible to pay to other party in case of breach of contract. As there is an element of risk involved in business agreements, limitation of liability clauses are found in almost all contracts. The purpose of limitation of liability clause, in simple words, is to limit the liability of parties. For example, if you and me are entering into an agreement wherein I'm going to provide you software services, and I agree in the contract saying that if there is a breach of contract or I fail to provide you services, I shall pay you a particular amount of money. And if there's a breach of contract, you cannot claim anything beyond that cap or limit we put on the liability. And however, if there is no limitation of liability, it's up to you. You can claim any amount of damages as per your intent or whatever you feel is right. So now we will go to the parts of limitation of liability clause, and the first part is about the amount cap. So as I was discussing that the parties can agree upon the a cap or a limit on the amount which will be awarded to the aggrieved party in case of any breach of contract. And there are certain exclusions as well, which are part of the limitation of liability clause. And whenever any limitation of liability clause is drafted, there are certain items which usually are excluded, and those are indirect damages, consequential damages, or damages which cannot be foreseeable. There can be loss of profit or anything else which basically is not directly associated with the services provided, or damages which are not direct. And apart from that, there are certain things which are excluded explicitly from the cap, are usually confidentiality and infringement of intellectual property, because usually the loss or expenses incurred on intellectual property claims or breach of confidentiality are quite high, and these cannot be ascertained easily. So usually parties exclude the cap or put an exception on the cap saying that this cap will not be applicable on breach of confidentiality and breach of intellectual property right. But recently there is one more addition to this, that is breach of data privacy laws. And data privacy laws has recently got a boom after GDPR was enacted, and there are a lot of parties who come in front and ask their opposite parties or customers or clients saying that they also want an unlimited liability in case of any breach of data privacy or customer data. So, friends, I would like to conclude with this point, and I would say that limitation of liability clause is a very important clause in any agreement, and often this clause becomes deal breaker or deal maker in any agreement. So, I would wish you all the luck, and if you would like to add anything or any suggestions if you have, please feel free to comment. Thank you.